The record reflects we are back in session. Parties and guests are present. All members of our jury and alternates are present. And Ms. Rodriguez, you may continue your examination.
Yes. Now, Ms. Blake, you were asked a series of questions about that specifically related to whether or not your son Joey had wanted to get rid of Chase as a welder. Do you recall that?
Yes.
In fact, you were given a particular section to review where you indicated that he was also attempting to get rid of Dan Kavanaugh. Do you recall that?
Correct.
And do you recall being asked that Joey was going to buy Dan and Chase out?
Just Dan.
Well, let me ask you to review page 158 of that transcript.
This is of an interview.
This is of an interview with Detective Steers. You can just review for me. Do you recall talking about that with Detective Steers?
Yes.
And did you tell Detective Steers that Joey was going to buy Dan and Chase out?
Yes.
And when you had gone to the house, I just want to clarify this for the record. When you went back to the house on February 16th, which you were just asked about on direct examination, do you recall that?
Yes.
You actually went to the house on February 16th with MacGyver, correct?
Correct.
And it was later that you went with Blanche and Kathy, right?
Many months later.
Like May or June sound familiar?
More like June.
Okay. And then you were asked about some specific deposits. You indicated that there were times that you would give the defendant cash. Do you recall that?
I have.
And so looking at Exhibit 985, we see a check that you wrote to yourself on April 6th for $2,500, and that would be on page 33 of the exhibit. Do you see that?
Yes.
And then looking at a deposit from the defendant's bank account from that same day that is contained
Your Honor, I would
in Exhibit
object. Your Honor,
436.
Just a minute, please.
I would object as the foundation with this witness to having testified about bank records.
Sustained.
Would this be consistent with the deposit that you gave the defendant, or with the
Objection.
cash that you gave the defendant?
Objection.
The objection
Speculation.
is sustained on foundation and calls for speculation and conclusion.
But you testified that you gave the defendant cash, correct?
I have, yes.
And you haven't reviewed his bank account to determine what he did with that cash, right?
Correct.
And the transactions where you did write checks to yourself, those were used for the business, right?
Correct.
And you haven't profited in any way from the disappearance of your son and his family, is that right?
That is correct.
I don't have anything further.
Moving on, redirect.
Ms. Blake, you were asked about these checks. After you were asked, when you previously testified, did you receive any money from that account? I specifically asked you. You said no.
Objection, argumentative.
Sustained. The objection sustained is argumentative. Ask the next question.
And now, counsel just asked you, he said it was used for business purposes.
Objection,
Correct.
argumentative, misstates the previous testimony.
Overruled.
So, besides the shipping and the FedEx, what business purpose was the $20,000 used for?
Objection, Ms. State's testimony asked and answered.
Sustained as asked and answered and cumulative.
Now, you watched the trial periodically in the beginning, correct? You were coming fairly often in the beginning. Is that right?
Yes.
And did you watch the testimony of the owner, not the owner, the president of Geis Construction? Remember, his name was Jeffrey Martin.
I don't think I was here then.
Do you recall getting any money from Geis Construction?
You mean a deposit?
Any kind of money? A wire transfer, a deposit, a check, anything?
I don't remember unless you can give me a name.
Well, do you recall there was a discussion about Geis had paid for their waterfall? They had sent 2 payments of $62.50, and Mr. Rodriguez asked you, Geis Construction had to send additional money to Geis Construction.
Objection,
correct?
lacks foundation. She didn't see his testimony here.
Sustained.
I'm going to show you page 13 of your bank records at Chase Bank, okay? Let's take a look at that. We're going to go to the top of the, I want you to take a look right, the area that I'm pointing out, you can see where I'm pointing, but it's at the top there. May 7th, there's a entry there. You see that? It says, in addition to the account or a deposit into the account, it looks like by Fed wire. So it looks like it's a wire transfer. You see that?
Yes.
And that also indicates it's from Geis Construction. You recall that?
I see that.
Okay. And that was $6,250.
Yes.
Do you recall receiving that money?
Obviously, yes, it's on the bank statement.
Do you recall what you did with that money?
It was in the bank account.
Do you recall Geis as one of the companies that was calling you?
Not,
You
not,
wanted their waterfall?
not that name.
Do you recall Chase calling you and saying he needs the
Objection,
money,
hearsay.
that he needs the money that you got so he can complete the Geis Construction waterfall?
Objection, hearsay. Assumes facts, not evidence.
Repeat that, please.
Do you recall Chase telling you that he needed the money that he received so that he could complete the Geis waterfall?
I don't remember Chase exactly saying that because he always wanted money.
What was your understanding of how waterfalls were going to get done unless you gave money to Chase?
Objection argumentative.
Sustained as argumentative.
Did you think that the waterfalls, you understood that Chase needed to be paid so that he could go buy the materials to finish these waterfalls, correct? You knew that.
Objection, argumentative, asked and answered.
Overruled.
I thought Chase was already paid for several of these waterfalls, and they need to be completed to be sent out.
And what makes you think that?
Because you have a handwritten paper that I gave you that Chase handwrote out, and that he was paid for these.
Okay, he went over every single account with you that you had questions about, correct?
On that sheet at that time, yes.
So, on that account, on those entries, was there anything about Geis Construction?
I said I don't remember the name Geis. Maybe another name. It also states on that form that he was overpaid.
This, I'm going to show you, this is the form that you're talking about.
No, you're missing some of this. There's another page.
Is there an entry on those pages regarding Geist Construction?
This, no.
There's a person by the name of Christina Martini. You know who that is?
She was a lady that ordered a fountain.
Okay. You know if she was associated with Geist Construction?
I don't know. You're missing a page.
Counsel asked you, Mr. Rodriguez asked you about the 9th of February when Chase came to your home, when he stopped by your home. Do you recall her just asking you about that?
Yes,
Okay. And you indicated that he asked for money or he didn't seem concerned, or she said that and you agreed with her?
correct.
Is that right? Okay. Let's just go back and just so we're clear. When you were interviewed by Detective Steers back in August of 2014, and you're asked about that encounter, Detective Steers specifically asked about when Chase showed up at your house on the 9th. I'm going to have you read pages 50.
Through 52, okay? Sorry to make you read, but it's right at the bottom, so it's really, many pages here.
So just start here.
Yeah, right at the bottom. But of course, you can read anything you want, but that's where it stops.
Okay.
Page 52.
No. Okay.
You want to read some additional pages? So, when Detective Steers asked you about Mr. Barrett's demeanor when he came up to your, when he came down to your house on the 9th, you told Detective Steers that he was worried. Is that correct?
Correct.
And he even said you deal with people all the time. What do you mean? You said he was worried. You recall that?
Yes.
Okay. Because he was worried, right?
About what?
About your son.
Yes.
He told you that.
Thank you.
Anything I would,
It's great. Okay, going back to exhibit 985, you were asked specifically about a deposit from Geis Construction. Do you recall that?
Yes.
And in fact, on page 13 of that, we see that actual wire into that account for $62.50, right? You see that?
Yes.
And that's May 7th, right?
Yes.
Now, these deposits or these bank statements, do they go to your house?
Yes. Oh, no, I'm sorry, no.
Whose house did they go to?
They went to Mikey,
So
my son.
you didn't get these bank statements at your home, right?
I honestly don't remember if we both got them. I don't remember.
Okay, well, if they sent them to an address in Capistrano Beach, you didn't live there, right?
Correct, that's not me.
Okay, so going back to this, we see a statement, we see this $62.50 deposit, and then on that same day, we see checks that you wrote to Mr. Merritt. The first one,
Objection has to be answered.
Yes.
Just want to do-
Can we have projector back, please? Mr. Jackson, thanks.
and then we see, maybe we don't see. There. Okay, so we see a check on May 7th to the defendant for $2,800, right?
Yes.
And we see another check to the defendant on May 7th for $2,000, right?
Yes.
And then yet another check to the defendant on May 7th for $1,200, right?
Yes.
The total of those three checks would be $6,000, right?
Yes. Well, I need to add.
Okay. And those three checks. I don't have anything for you.
Anything else?
You don't know what those checks to chase what specific projects they went to, correct? You don't know what
Objection
they were.
asked and answered.
I'll repeat that?
The specific checks that she just listed, you don't know what projects they were destined for, do you?
No.
Okay. And I know you don't want to add up the total deposits for the account. I'll let you know it's 36,000. Does that sound about
Objection beyond
right?
the scope.
Sustained.
You recall depositing or receiving funds in that account? Do you know how much of total funds you received?
Objection beyond the scope.
Honestly, I do not. I wasn't in the right frame of mind.
Thank you.
Anything else?
No, Your Honor.
Any objection to Ms. Blake being excused again at this time, still subject to the call?
No, Your Honor.
Thank you again for coming in, Ms. Blake, and you're excused. We're going to be recessing in about 10 to 15 minutes. Did you want to start with your next witness?
Up to the court.
Well, we can approach on that.
Sure.
We don't need to.
A little bit earlier even. The next witness apparently isn't available tomorrow, so rather than start with him for 10 minutes now, I have to bring him back at a later time. We'll just go ahead and reschedule him when we can get all of his testimony in. So, according to my schedule, we're here all day tomorrow, right? Yes? Okay, so that's what we'll plan on anyway. We'll be in recess till 9:30 tomorrow morning. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case or allow anyone to discuss the case with you or in your presence, and we'll see everyone back at 9:30 tomorrow morning. There was a motion made to not permit the playing of the entire interview on the basis of part of it was played. So if you could provide that to me, I can start going through that. And if you can also provide, I know we haven't, but I don't know what the exhibit number is, the transcript of the excerpt from that interview that was played.
We'll get you that exhibit. Do you mind if the transcript's emailed to you? Or to Loris? It'll obviously be quite long.
No, the 800, the 8-hour transcript, no, I'd rather just have you bring that in.
Okay. We'll kill a tree for you, Judge. Double-sided or single-sided?
Single.
Okay?
Double space 14 font. Okay, I think that's
I do have one matter to address, Your
on the
Honor.
record.
Yes.
Sure. Record reflects we're back in session. Parties of council are still present. The jurors are not present.
Previously, I had brought it to the court's attention that we had seen some pretty flagrant attempts by defense counsel to circumvent the court's 402 rulings. And I would like the court to address the fact that Mr. Moline did that yet again today by attempting to ask Susan Blake about Mr. Kavanaugh's comments to shut down the business and things like that. That was the subject of a pretty lengthy motion, and the court specifically excluded that email conversation between Joseph McStay and Dan Kavanaugh. And we saw Mr. Moline again attempt to try to get into that with Ms. Blake by asking her about Dan Kavanaugh trying to shut down the business.
Call for a
We had a very specific one because defense counsel wanted to show a whole email exchange between Joseph McStay, and this was, I think, part of the third-party culpability motion. And that email was about a year before the family actually went missing, and that was part of that third-party culpability motion, Your Honor. And the defense keeps attempting to elicit testimony with respect to things that this court has ruled are not admissible.
The court has not ruled that the issue of the fact that Joseph wanted to buy out Dan is not admissible. What the court, my understanding was, we gave the court a specific 10 or 15 page threat from Dan Kavanaugh to Joseph. That's what you indicated was not admissible. But the issue of the buyout has come up a dozen times or more in this trial already. So it has nothing to do with the threat.
Right, no, I agree that the issue of Joseph wanting to, or in fact, buying out Mr. Kavanaugh certainly has been relevant. There's been ample testimony about that. But I did make it clear that the other issue was not relevant. It did appear you were attempting to ask Ms. Blake about that particular email.
No, absolutely not. In the transcript, it said that she told the detectives in her interview that she wanted to buy out, that Joseph wanted to buy out Dan. Joseph wanted to buy out Dan because he had threatened to shut down the website. It had nothing to do with that long 15-page threat, which we still believe is relevant. We plan on making a motion, so the court and counsel are aware. Our plan is to ask the court to reconsider. We believe that the state of the evidence at this point has changed the dynamics, and that is a motion that is going to be coming before the court at some point. But not now, would I ask about that email. She wouldn't know about the email, and I didn't ask her about the email. But it was common knowledge.
She would know about it.
It's common knowledge that Dan said that I can shut down your website at any time. That kind of talk had been going on, and that's one of the reasons Joseph was buying him out.
I think we can get the transcript and we'll see exactly the question that Mr. Moline asked, because it was very clearly about an email exchange to shut down the business. It had nothing to do with just the buyout. His question was not solely related to the buyout.
I do remember him asking about the reason that Joseph wanted to buy out Dan was that, isn't it true that the reason that Joseph wanted to buy out Dan, or at least one of the reasons, was because Dan threatened to shut down the business?
That's exactly what you told Detective Spears.
It doesn't matter, this court ruled that that information or that exchange
Yes.
is not admissible at this point. And if they want to file their motion to reconsider, that's one thing. But this court has not reconsidered that at this point, despite the fact defense has brought it up a couple of times.
Well, the defense's perspective would be the people opened the door when they asked, isn't it true he wanted to buy out Dan and Chase? Once they said wanted to buy him out, they're bringing that up with her, then we get asked, well, why would
No,
you?
I made it clear in the earlier rulings that the issue of the buyout and the ultimate sale of the business, who got the proceeds of the sale, was admissible. And both sides have asked questions about that. And even if something were asked that someone believes has now, quote, opened the door to go into something that the court had already expressly ruled to be inadmissible, the appropriate procedure is to bring that up to the court outside the presence of the jury, not to go into it in front of the jury on your assumption that the door has been opened.
And once again, we're prejudiced because they bring up Dan Kavanaugh, and we have to continue to keep objecting to that information because they're violating the court's orders.
And ringing the bell in front of the jury, that's the inappropriate aspect of it, knowing that the court has made those orders. And Mr. Marine's now done it twice.
All right, well, to the extent that there was a question about the reason for the buyout being Dan's threat to shut down the business, I think that is not attempting to go into the areas that the court has ruled. And
Your Honor?
just a minute, what is at least equally distressing to me is when there is a proper objection, when the court sustains the objection, it is unprofessional, improper, and contemptuous for counsel to make a joke of the objection and the ruling. And I'm telling you now, if you do it again, I will hold you in contempt.
I apologize to the court. I apologize now, and I apologize at the time as well. And I don't do that lightly. I do it.
I understand that it's a tactic to try to perhaps ingratiate yourself to the jury or to make it sound like it's not a big deal, but it's improper and it's unprofessional. And if, I'm warning you now, if it happens again, I will hold you in contempt for it.
I agree, and you only have to tell me once, Your Honor. But
I hope
at the same time, this type of conduct goes on constantly with these prosecutors. They constantly object, and they do speaking objection. Just because we don't say it every time doesn't mean we rely on the court at some point to say, hey, wait a minute, you can't keep doing that. You tell us not to do speaking objections. It is a constant with them.
Both sides have been guilty of that, and that also is improper. But you know, my ability to control that has been demonstrated to be not very good. So,
well, I mean, I understand the admonition to me, and I certainly adhere to it. I will adhere to it. I'll follow all the court's orders. At the same time, at some point, they can't continue to violate the court's order. You've told them more than one time to not make speaking objections, and they continue to do so.
Both sides have been guilty of making speaking objections, and speaking objections where you're arguing either the evidence or the merits of the objection and voicing the objection in front of the jury, and that's also improper. So, should be advised, again, if you have an objection, you state the legal grounds for the objection, and that's all. And if I'll rule on it, and if you feel the need to approach, you can request to do so, to argue. I'm less and less amenable to approaching every objection. But sometimes I understand the need for it, I'm willing to do it other times, yeah. So,
And we appreciate that, Your Honor. The multiple grounds for an objection is not a speaking objection. And the fact that the question is poorly formed and subject to multiple objections
well,
doesn't make a speaking objection on our part.
no, it's not a speaking objection, say, hearsay, lack of foundation, calls for speculation. But it is a speaking objection to go on to explain why those grounds apply or why those grounds do not apply. Or why, it should not be sustained.
And so you don't want us saying what the witness is being asked to assume, for instance.
No,
Right, okay. Thank you.
I can usually figure that out.
Sometimes.
I used to do this,
Thank you.
Okay. So you get those transcripts to me.
I found them, I will cut down a tree for you, Judge.
Okay, thank you. And then I'll start to go through those along with the additional motions that we filed.
The other hand being raised for that.
Your Honor, I spoke with Mr. Michael McStay. He's available on the 28th.
What day?
Next Thursday, 28th in the morning.
Okay, that's a day we were planning on being here.
Well, maybe if, I'm not going to be here, so it doesn't matter. I guess they're going to call Mr. Beasley on Wednesday. I suppose we could interrupt this
Mr. Who?
About Beasley?
Okay.
Which we probably need to litigate before it happens.
I just saw the motion on that, so I'll look at it. But,
Just get interrupted.
okay. So, that's fine. So who do we have on for tomorrow and Wednesday?
I'm sorry?
Who do we have on for tomorrow and Wednesday?
We have some officers tomorrow, and then I was gonna do Mr. Beasley, start tomorrow and do Wednesday, but as we discussed in the chambers, there's some discovery that needs to be compiled and given to the DA's office. I want to get that in a timely manner. And so he's working on getting the request that they made to me over the weekend.
So you're going to start the direct before you give the discovery?
No, that's why we're rescheduling him back, and that's why we were talking about in chambers, not starting him until after we get the discovery.
Right, that's what I thought.
Yeah, and so that's why everything's being pushed back. So I'm not sure if we're gonna have anybody for Wednesday just yet. I'm trying to see if I can get somebody. That became a whole problem with the experts were all not available until April.
And I appreciate that. It's frustrating, but I appreciate you can't have all of your witnesses sitting out in the hall ready to go.
Right.
As frustrating as it is, I accept that as part of what we have to do. Okay.